The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your generally bi-weekly podcast on the federal courts of appeal. I'm your host, John Ross, joined today by IJ Senior Attorney Paul Sherman and IJ Attorney Kirby West. Let's kick things off in the 11th Circuit. Paul?
Well, there's no way around it. We are just going to have to science the heck out of this case. And when we're done with that, we're going to have to law the heck out of it. Those are the opening sentences of this decision in a really interesting case that raises a number of issues. From a libertarian perspective, I think it's fascinating because it shows when you have a black market, there really is no limit to human ingenuity for trying to get around that. But from the legal side of things, it also shows how courts approach it when canons for interpreting statutes conflict with one another. So what this case is about is the DEA's ability to regulate what are called positional isomers of drugs that they have temporarily added to the drug schedule as illegal drugs. The reason why they have the power to do this is because people are endlessly creative, and every time the DEA schedules a drug for inclusion on the list of illegal drugs, it takes about 6 to 12 months to get those regulations finalized. And in the meantime, chemists are able to come up with chemicals that are similar to the drug, but not the same. And so the DEA has been given the power to temporarily list things on the schedule and also to cover chemicals that are sufficiently similar. So the issue in this case, a gentleman was caught with a chemical called ethylone. And the question is this a positional isomer of butylone, which is a drug that's currently on the schedule?
Kirby, so what happened to this guy who got caught?
So he did not argue that he didn't have the drug on him. He acknowledged that he did have the ethylone, but what he argued is that it is not a positional isomer by the true scientific definition. And to prove that, he brought in an expert who discussed what a positional isomer is, which was contrary to the DEA's definition of a positional isomer. The court in the jury instructions gave, over his protest, the DEA's definition of positional isomer. So now on appeal, the court is considering, was that correct? What is a positional isomer? Is ethylone truly a positional isomer of butylone? For this, there's a very good advertisement for Khan Academy throughout this opinion. The court gets really into the chemistry of this. I had some flashbacks to high school chemistry, not positive ones, and really trying to engage with what is the true definition, ultimately coming to the conclusion that both the expert's definition and the DEA's interpretation of the regulatory definition of positional isomer are both reasonable interpretations.
Yeah, and part of the issue here is the DEA has this broader definition of Well, I guess to back up, a positional isomer is a chemical that has the same chemical elements in it as another. They're just arranged in a slightly different order. And some definitions of positional isomer are broader than others. The DEA is using this broader definition that encompasses another type of isomer that's called a skeletal isomer. And in that one, the carbon backbone of the chemical is different than in another one. So the question is, which of these should control? Typically, in these situations, we expect, if you listen to the podcast, that judges are going to defer to the interpretation that's offered by the agency because they're viewed as the experts. In this case, that's called Auer deference. But there's a rule that counterbalances that, which is that in criminal cases, if a statute is ambiguous and subject to more than one interpretation, you have to go with the interpretation that favors the accused because people need to be on fair notice of what is and is not illegal.
As much as I did not enjoy the chemistry elements of this opinion, I did really like the battle of the canons. The rule of lenity is my favorite canon of construction, not only because I think it has some inherent sense of justice, that you shouldn't be punished for something if we're not sure that the government meant to punish you for that thing, but also it has a pretty strong pedigree, probably the strongest of any canon of construction. It goes back to the 1500s in English law, where the courts were trying to kind of stem some of Parliament's bloodlust and try to avoid giving the death penalty in particular cases. So I think the court really placed the correct value on that canon in acknowledging that the rule of lenity should be superior to Auer deference.
Yeah. So so that's ultimately the question: does Auer deference trump lenity, or does lenity trump Auer deference? And the court says lenity trumps. Auer deference does not apply in criminal cases. I think this is a good ruling. It comes at an interesting time when a lot of these canons of deference, like Auer deference or like Chevron deference, are coming under a lot of criticism. And so this seems to be part of that broader trend. And if this goes up, it may actually be a chance for the Supreme Court to pare back Auer deference.
So looking through my Constitution now, you can imagine that I'm doing that. Where do you see the rule of lenity or even any of these deference doctrines?
Well, I think the rule of lenity can at least be derived from the notion that people are entitled to due process of law. And one of the elements of due process of law is notice. You have to be on notice of what the law prohibits and what it doesn't prohibit. And in cases where that's unclear, we should have a thumb on the scale on the side of the accused. As for where the deference canons like Chevron deference and Auer deference are in the Constitution, well, they're not in the Constitution, and that's a big part of the criticism, is that we are violating the separation of powers because courts are typically the ones who interpret what laws mean, and they are ceding that power to the executive branch whenever they defer to the executive branch's interpretation of the law. But that didn't happen here. Now, it doesn't mean that this guy's going to get off scot-free. What the court did is they remanded the case back to the district court, which is going to have an evidentiary hearing on what are the scientifically accepted definitions of positional isomer. And then it's actually going to be a question of fact for the jury whether ethylone is a positional isomer of butylone.
To Paul's point, I think this is a really powerful example for people who are concerned about the size and power of the administrative state, that decisions of unelected regulators do have very real consequences for a lot of people across the country.
Okay, and with that, let's move on to the next case, which comes out of the Ninth Circuit. Kirby?
So this case deals with the city of Boise's efforts to deal with a very long problem that is familiar in cities across the country, which is homelessness. In response to homeless people sleeping in public places and parks and sidewalks, the city has two statutes. The first is a camping ordinance that prohibits camping in public places. The second is a disorderly conduct ordinance that prohibits occupation of any building or place without the permission of the owner. So for homeless people, that means it's a misdemeanor to sleep in public places under the camping ordinance. And of course, it's illegal to sleep in someone's private place without the permission of that person. The plaintiffs in this case are 6 homeless individuals who were cited under these ordinances. They were given a very small fine and time served, but the question is still, is any punishment appropriate for homeless people who have no choice but to sleep in public?
And this is an interesting case because it raises a question that the courts don't confront very often. So the claim that they've brought is a claim under the Eighth Amendment that this is cruel and unusual punishment. There's a ton of case law out there on the Eighth Amendment. In fact, the Supreme Court heard an argument just yesterday on whether certain types of capital punishment for certain criminal convicts is consistent with the Eighth Amendment. Here, the question is one of proportionality. If a offense is minor, is any punishment acceptable for that, or is the kind of misdemeanor punishment they're doling out here cruel and unusual?
Yeah, the court actually cites an opinion from that body of jurisprudence that says 1 day in prison to punish the common cold would be, grossly disproportionate or something to that effect, which is, makes sense that it doesn't really matter what the punishment is if what's being punished can be by no stretch of the imagination thought to be criminal conduct.
So the court's holding here is that, yes, this is a cruel and unusual punishment, but they characterize their holding as being really narrow. Can you explain that, Kirby?
Sure. So before they get to the actual merits, there's a lot of back and forth on procedural issues in this case. It was at the district court. They granted summary judgment for the city. It went up on a procedural issue. It went up and was reversed and remanded, and then summary judgment granted again on another procedural issue. The court kind of gets through that procedural issue, but when they get to the Eighth Amendment claim, they do say that in this particular instance, they look at the homeless shelters in Boise and how many beds are available to homeless people in Boise. There are, by one count, 867 homeless people in Boise as of 2016. The court notes that these kind of numbers are pretty inaccurate often because it's a spot check of one night how many people are out and about sleeping in public. But regardless, even by that, perhaps inaccurate number, there are only 354 beds and then 92 overflow mats, so a total of 446 spots available for shelters. So at least in a circumstance where there seems to be no alternative for at least some of the homeless population, there's no shelter that they can go to if they're more homeless than there are beds available. It would be cruel and unusual to punish them for sleeping in public.
This is an interesting time for this decision to be coming down, too, because of the current vacancy on the U.S. Supreme Court created by Anthony Kennedy's retirement, because Kennedy, as he was in so many areas, was the swing vote on Eighth Amendment cases. And he often sided with the court's liberals in determining that, mostly in death penalty cases, that certain punishment was cruel and unusual. Now that he's gone, if this case goes up to the Supreme Court, it's not clear how it might turn out, because now there's a 4-4 split.
It is interesting that this was only an Eighth Amendment discussion. Initially, when I was thinking about this case, I thought there is probably some right in the Constitution to, exist in public if you're a poor person and don't have a home. But I wasn't sure that the Eighth Amendment was the right way to attack this. But after reading the opinion, I actually think, though there might be other ways to think about this as well and other constitutional rights at issue, it does seem right. And the Eighth Amendment jurisprudence is a little bit squishier sometimes and related to our kind of current norms in a way that other constitutional provisions are not, and in the way that the court has often spoken about it. So to me, it seems like a solid position. But you're right. Given the current makeup of the court in future, it would be hard to predict how the court would come down.
Yeah, I agree with that. I tend to think that, the other approach you could take is the one you've suggested, which is that there just must be some fundamental unenumerated right to, if you don't have a home and you're biologically required to sleep, you have to be allowed to sleep somewhere. So it seems like that has to be covered. Typically what we see is when there's an enumerated right that covers something, courts don't like to engage in the analysis of the unenumerated right. And I think at least here, his chances, if this goes up to the Supreme Court, are a lot better with an Eighth Amendment claim than they would be with an unenumerated rights claim under the 14th Amendment.
Right, that's definitely true.
Kirby, you mentioned there were a whole bunch of procedural hurdles to overcome. This case was originally filed in 2009. The laws in question were tweaked in 2014. Could you tell us a little bit more about that and how it influenced the course of events here?
Sure. One of the arguments of the city was that this was no longer an issue because in 2014, the city codified a police procedure called the shelter protocol, in which if at any given night all of the shelters said our beds are full, we have no more room to accept homeless people, then on those nights the police could not enforce these statutes. What the court says is that doesn't really capture the whole picture of the situation on the ground for homeless individuals in Boise. First, some of these shelters have a policy by which they will never turn people away for overcapacity. So they have these mats that I mentioned earlier, and they will just basically make room for whoever shows up. So they're not going to be reporting to the police ever when they do reach capacity. Another issue is that a lot of these shelters, there are only 3, but each of these shelters has some kind of restriction on the number of consecutive nights you can stay there. So even though they're not at capacity, they might not be available for certain individuals. At least 2 of the shelters also have a religious component that certain individuals find incompatible with their own beliefs, and they choose not to go to those shelters for that reason. And the court says you can't force people to engage in religious behavior, and that raises a whole other host of issues. So for all of these reasons, the shelter protocol that was codified in 2014 really did not solve the question in the case.
Okay, let's move on to the final case. Paul.
So this is a First Amendment case arising in the Sixth Circuit in Nashville, Tennessee. A couple of guys wanted to protest and preach against homosexuality at the LGBTQ Pride Festival in downtown Nashville. The Pride Festival had reserved this space in the park so that they could have the festival. These guys were on the sidewalk in front of the park with bullhorns preaching against homosexuality. Eventually, the police intervened and forced them to move across the street. And the question is, does this violate the First Amendment or not? And as with so many cases, this case illustrates just the vital importance of the standard of review to constitutional litigation. Most people when they think about things like the First Amendment, they just assume, if the First Amendment is implicated, then the government loses and the speaker wins. But it's much more complicated than that. There are situations where the government has to meet a very high standard if it wants to regulate speech, and then there's situations where it has to meet a much lower standard. The central question in this case is, which standard does the government have to meet? And
Nashville was so sure that it was the lower standard that they did not even bother coming up with a compelling reason to restrict the speech if indeed the court chose to apply strict scrutiny, which it did here.
Yeah, and this is something that we at IJ see in a ton of our cases, because we often argue that the appropriate standard of review is strict scrutiny, the highest standard of review, and very frequently the government places all of its eggs in the either the intermediate scrutiny basket, or they'll argue that the First Amendment doesn't apply at all, and they'll put all their eggs in the rational basis basket. In this case, the central question is whether the regulation of these preachers' speech was content-based or content-neutral. And this is a critical distinction in First Amendment law. It's one there's been a lot of litigation about in recent years. The standard for it has become much more speech protective than it used to be. But the reason why it matters is the sidewalk is a traditional public forum. People just historically have always been able to protest on the sidewalk. The government can't regulate protests in public forums based on the content of those forums, based on the message that's being conveyed. But they can enact what are called content-neutral regulations, so regulations that don't turn on the message, that regulate the time, the manner, or the place of the speech. So, for example, the government couldn't pass a regulation that says you can't talk about politics on the sidewalk, but you can talk about art. That would be content-based. But the government could pass a regulation that says you can't use a bullhorn on the sidewalk after 10 p.m. That would almost certainly be seen as a valid content-neutral regulation.
So in this case, Kirby, the speakers were using a bullhorn, and you could at least imagine an argument that, like, hey, they're being really disruptive. They're shouting in this park, and that wouldn't be content-based. That's not how the court decides it. Why?
Well, first, because the facts show that that's not exactly what happened, that it was just a ban on speaking through a bullhorn. Rather, the preachers contacted the city prior to the event, and the response indicated that it was the content of their speech that was going to be a problem. But further, Nashville kind of almost acknowledges this in the arguments to the court. First, one of the very first allegedly non-content-based reason they give for this restriction is that the preacher's message of intolerance of homosexuality interferes with the message of the Gay Pride Festival, which on its face seems to refer to the content of their speech. And later on in the oral argument at the district court, the court here quotes the Nashville attorneys saying, it's hate speech, which is still protected under the First Amendment, I guess. But let's not pretend they're just out here handing out leaflets. So I think the facts when it happened and then the lawyers' arguments later all point in the direction that it was really the content of the preacher's speech that motivated the actions of the government here.
Yeah, there's a classic line that lawyers use, which is that you can't win a case at oral argument, but you can lose one. And that seems to be what happened here. The lawyer for the city just made extremely damaging concessions. One of the disagreements between the majority and the dissent in this case is how much weight should those concessions be given. To me, I think in this case, the lawyer for the city was just saying what everyone must recognize to be obvious, which is that if these guys had been out there with bullhorns promoting a message of tolerance towards gay people, they would not have been asked to move. They were asked to move because they were promoting a message that people thought was hateful. But in a traditional public forum, you can't make those kinds of distinctions. It's not permitted.
Paul, you mentioned there's a dissent. What was the crux of the disagreement?
So the crux of the disagreement, again, was whether this is content-based or content-neutral. What the dissent seems to think is that if they had just been peacefully leafleting, they would not have been asked to move, and that anyone who was using bullhorns would have been asked to move. I think it's probably likely that if they had been leafleting, they wouldn't have been asked to move. But I think it's implausible that if they had been saying messages that were supportive of gay rights, they would have been told to move across the street.
On a related note, I think that kind of is something that comes up in First Amendment debates quite frequently. People are very comfortable with First Amendment speech of people with whom they disagree, as long as it's pretty ineffective. So if the speech is something that we can ignore and nobody will really see, if it's leaflets, I can handle the First Amendment in that context. If it's something that I'm really going to have to confront and deal with, maybe that changes the analysis a little bit.
Yeah, I think that's exactly right. I mean, I've said this so many times, but if you want to look at what are the really bitter fights on the Supreme Court, like the 5-4 battles, they are not the fights where the speech is merely offensive. In fact, those cases tend to come out 7-2, 8-1. They're the cases where the speech is effective, where they might persuade people. Now, I don't know that the speech in this case was particularly persuasive, but it was confrontational in a way that that's the sort of speech that's going to need First Amendment protection, because it's the speech that people are going to notice and object to.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next time for more judicial engagement. Until then, this is John Ross from the Institute for Justice, contending that you should get engaged.